ladies and gentlemen. Thank you for tuning in for another video. Tonight, I want to discuss the issue of the Reggae Girlz trademark. I've previously called your attention to the results of searches conducted on the U.S. Trademark and Patent Office website, which provides the public with details concerning the registration of trademarks in the United States. As seen here, the Reggae Girlz Foundation has been listed for the past 4 years as the presumptive owner of the Reggae Girlz trademark. The Reggae Girlz Foundation, Inc. submitted an application for registration and ownership of the trademark on February 8, 2019. The application notified the Trademark Office of the Foundation's intention to use the trademark on t-shirts, pants, jackets, footwear, hats, caps, and athletic uniforms. Additionally, the Foundation's application states that it sought to use the trademark for charitable donation services, educational, recreational, and entertainment services in the field of soccer competitions, camps, entertainment in the form of soccer games, and providing sports news in the field of soccer. As you can see here, it says that the application was published in the Trademark Official Gazette for opposition on June 18, 2019. That means that the U.S. Trademark and Patent Office is affording any entity with a competing claim to ownership of the trademark the opportunity to oppose the Reggae Girlz Foundation's registration as the owner of the trademark. If no opposition is filed, the U.S. Trademark and Patent Office will issue a notice of allowance. A notice of allowance is a written notification from the U.S. Trademark and Patent Office that a specific mark has survived the opposition period. This does not mean that the registration of the mark has been completed. Rather, receiving a notice of allowance is another step on the way to registration. Notices of allowance are only issued for applications which express an intent to use the trademark in connection with the sale of merchandise and commercial branding. The applicant has 6 months from the mailing date of the notice of allowance in which to either file a statement of use, that is, a statement describing the commercial use of the trademark, or if they cannot produce such a statement, the applicant must file an extension request. If the applicant does not file a statement of use or extension request within 6 months from the date the notice of allowance is issued, the application is considered abandoned or no longer pending for approval. The Reggae Girlz Foundation submitted another application to register as the owner of the Reggae Girlz trademark on February 14, 2022. The application is almost identical to the former abandoned application. The new application is pending. As seen here, it says that the application has been accepted by the U.S. Trademark and Patent Office, but it has not yet been assigned a trademark examiner who will either approve or deny the registration. During this time, another period for opposition will commence, where any entity with a competing claim can challenge the Reggae Girlz Foundation application. Additionally, let me pause to say this. While owning a trademark registration provides many significant benefits, registration by itself does not conclusively establish the owner's exclusive right to use the mark. A trademark registration can be invalidated if the person or entity claiming ownership is not the one controlling the nature and quality of the goods or services under the mark. Furthermore, prior users have significant protection under the Trademark Act in any trademark dispute. Therefore, while a registrant might be listed as a presumptive owner, an unregistered prior user may still be found to have superior rights. An article published in Sports Illustrated Soccer describing a trademark battle between the United States Soccer Foundation and the U.S. Soccer Federation illustrates the problems, principles, and loss of opportunities related to the failure of the JFF's executive to register and complete the process to own the Reggae Girlz trademark. The article notes that while the U.S. Soccer Foundation and the U.S. Soccer Federation have coexisted for nearly 3 decades and engaged in joint ventures, The U.S. Soccer Federation has recently demanded that the foundation cease all use of its trademark. Although the U.S. Soccer Federation and the U.S. Soccer Foundation, which are both nonprofits, have extremely similar names, they are unique entities with very different functions. The U.S. Soccer Foundation is focused on expanding the sport of soccer in order to promote the welfare of children in underserved communities. In sharp contrast, the U.S. Soccer Federation is the official governing body of soccer in the United States. It oversees the promotion and regulation of domestic and international soccer. In doing so, the U.S. Soccer Federation pursues policies that fund, improve, and expand domestic and international football. One of its main fundraising tools has been the exploitation of its trademarks in connection with the sale of merchandise and the organization of competitions. It is believed that U.S. Soccer Federation's maneuver to prevent the U.S. Soccer Foundation use of the trademark and to reestablish its identity with the trademark constitutes a likely effort to capitalize on lucrative business opportunities when the United States hosts the World Cup in 2026. Regardless of its purpose, the U.S. Soccer Federation's demand is not without legal authority. The U.S. Patent and Trademark Office lists the U.S. Soccer Federation and not the U.S. Soccer Foundation as the rightful owner of a handful of trademarks for U.S. Soccer Foundation. This is true for gym bags, t-shirts, and other apparel. It is also true when providing services to advance the sport of soccer in the United States, namely conducting workshops, sports clinics, and seminars in the field of soccer, and when providing services to advance the sport of soccer in the United States, namely fundraising, program development, grant making, and scholarships. U.S. Soccer Federation attorneys registered these marks in the late 90s and early 2000s. These registrations were also approved by the U.S. Patent and Trademark Office after exhaustive reviews. Registration provides legal benefits to its owners. Those benefits include a statutory presumption that the trademark is valid, the registrant is the owner of the trademark, and that the registrant has the exclusive right to use the registered trademark. Although this lawsuit ended in a settlement where the entities vowed to continue to work together, the U.S. Soccer Federation re-established its dominance over the U.S. Soccer Foundation trademark and have since busied itself with the task of commercial exploitation of the mark. Of course, in contrast to the conduct of the U.S. Football Federation, the JFF has not sought to establish its ownership over the Reggae Girlz trademark. The Federation has never submitted an opposition to the Reggae Girlz Foundation's attempt to register itself as the owner of the trademark, nor has it sought to explain its arrangement with the Federation or any efforts by the Federation to develop and exploit this immensely important financial asset. Additionally, despite changes to Jamaica's trademark and copyright laws permitting the Federation to establish international registration from Jamaica, the Federation has not done so. While neither the burial bylaws nor the original constitution of the Federation require such conduct, it is unimaginable that with the example of the U.S. Soccer Federation's exploitation of its mark lingering so close to home, the Jamaican Football Federation would continue to complain about their inability to financially support the development of football on the island while simultaneously neglecting their birthright financial assets. Now let me be clear. I support the efforts of the Reggae Girlz Foundation. I too have advocated reaching out to the business community within our diaspora for sponsorship of our football programs. In an article published in The Gleaner on January 13, 2022, entitled Young Reggae Girls Have Support on the Way, the president of the Reggae Girlz Foundation, Michelle Adamcullen, stated that Jamaica has not been able to compete at the same level as other countries because we have limited resources. But through the foundation's work, we have the opportunity to support the women's football program financially. The foundation, she explains, works to understand where JFF have budget gaps, and then we support them through our fundraising efforts. Adam Cullen pointed out that the foundation raised 10,000 US dollars in partnership with an Atlanta-based Golden Cross restaurant just this year, and that the Reggae Girlz Foundation raised over $60,000 US dollars in 2019. Nevertheless, Adam Cullen emphasized that while the foundation works to support the Jamaican Football Federation's women's program, it is an independent entity with a 501c registration in the United States. With regards to the foundation's independence, I know that while the Reggae Girlz Foundation's website displays the pictures of Michael Ricketts, Dalton Winks, and Bruce Gaynor as JFF representatives to the foundation, it does not explain their role or official affiliation with the foundation. I have made repeated efforts to reach JFF in order to determine the role of the JFF executives. However, my efforts have gone unanswered. And given the JFF's reputation for scandal and mismanagement, the public and myself are left with little choice but to draw negative inferences on the part of the Federation. Among other things, as the facts present themselves, we are left to infer that the Federation has given either explicit or tacit permission to the Foundation to establish itself as owners of the Reggae Girlz trademark. If this is the case, such conduct on the part of the JFF would be unwise and damaging to the long-term prospects of Jamaica's football. Ladies and gentlemen, JFF's failures with respect to the Reggae Girlz trademark are not mere talking points. FIFA's good governance norms require that the Federation establish its ownership of the trademark and exploit it to further Jamaican football development goals. After all, FIFA funds federations in order to improve and enrich the sport. A federation's neglect or misappropriation of its own assets, while it continues to demand more and more from FIFA, violates FIFA's financial rules. At its own website, FIFA notes that its intellectual property primarily consists of trademarks and logos. It states that FIFA has developed and protected these trademarks, which it will use or allow others to use under a formal agreement. It further notes that FIFA is obliged to take action against any unauthorized reproduction of its marks in a commercial context. FIFA explains that if it did not follow up on any infringements of its trademarks and copyrighted works, it would risk losing its legal right and title to such works, thereby endangering the foundation of its commercial program. Concluding, FIFA contends that its commercial affiliates will only invest in FIFA competitions and the World Cup if they are provided with this exclusivity for the use of the trademarks. If anyone could use the official marks for free and create an association with FIFA, there would be no reason to become a commercial affiliate, according to FIFA. This would mean that FIFA could not appoint any commercial affiliates and would therefore not receive the revenue required to maintain the high standards expected of FIFA competitions. A non-profit corporation, such as the JFF, is, like any other corporation, also subject to something called the Corporate Opportunity Doctrine. Under the Corporate Opportunity Doctrine, directors, officers, and employees of a corporation owe a fiduciary duty to the corporation. It is a duty to take no action that would harm the corporation and to always act in the best interest of the corporation. Under the Corporate Opportunity Doctrine, officers and employees may also have a duty to take affirmative action to protect the corporation's interests, meaning they cannot just refrain from acting. At times, they must seize opportunities for the best of the corporation. Furthermore, pursuant to the Corporate Opportunity Doctrine, officers or employees of a corporation cannot seize for themselves a business opportunity that would otherwise go to the corporation's benefits. This is true whether or not the opportunity was discovered while performing duties for the particular corporation. Let me close by saying that knowledge is power. While I encourage the work of the foundation and acknowledge that given the JFF's inaction, the foundation is within its right to seek ownership of the trademark, I cannot overemphasize how intolerable the failure of the JFF to acquire this asset is. The endemic financial drought has set us back from the grassroots to the senior team levels. It stymies local development and recruitment from our diaspora. It creates an atmosphere of distrust, self-dealing, and conflicts of interest. The failure casts a shroud over the efforts of the Reggae Girlz Foundation, which, left with the reality of a failing federation, has sought to fill that essential gap. Let me call upon President Ricketts to take steps to correct this failure now. Mr. Ricketts, we await your response. Now, ladies and gentlemen, thanks for joining again for another video. I hope you will subscribe. Good night.